Morning's docket. That is case number 108494 in the matter of John C. Davis.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. We're here as a result of a hearing that occurred on May 24th of 2012. Respondent appeared in person at that hearing with counsel John Ambrosio. The respondent was admitted to practice in Missouri, the state of Missouri in 1968, and the state of Kansas in 1983. The respondent has been suspended by the state of Missouri, their Supreme Court, arising out of the same set of facts that bring us here today, for violations of 8.4 B, C, and D. He was suspended on May 1st of 2012 there for 3 years with no reinstatement hearing or petition to be entertained until the 3 years expire. This panel here found numerous violations of the Kansas Rules of Professional Conduct, including unreasonable fees, conversion of client funds, illegal conduct, and dishonest conduct. In connection with his responsibilities as an attorney and a trustee for the Dorothy Neville Trust. The respondent did not take exceptions to the findings of fact made by the panel, therefore they are deemed admitted. The respondent told the panel that he felt as though he should be indefinitely suspended. It was a recommendation of our office that he be indefinitely suspended. It was a recommendation of the panel that he be disbarred.
What is your position today on discipline?
It's the same as it was before.
The amount the finding number 13 was $801,906 was paid, was a total paid to his law firm as a result of his legal fees. Did that include the amount of the nearly $500,000 that was paid to his wife?
No, I think that was over and above that.
Over and above that, so we're talking about $1.3 million.
That's correct.
Thank you. One other question I had was I'm just curious in terms of the monitoring by the firm, the Stinson Mag firm. They only became aware of this 10 years after the fact, or 8 years after the fact, of the excessive billing and the practice?
If my recollection is correct, they would have found out sometime in 2010, but I'm not sure that there was evidence in the record about how they monitored that situation. It came about as a result of a review by the members of the firm of the person who was in charge of the lawyer who was in charge of the estate division. But I'm not sure there was any evidence in the record as to how often they reviewed the records.
And he'd been representing this woman for 19 years by that
Since
time.
1991, I believe,
Yes.
is the figure that sticks in my mind.
Yeah.
Mr. Hazlitt, the panel hearing report, the way I read it, indicated that the Missouri suspension was based only on the conversion and not on the billing issues. Is that correct?
Your Honor, I believe that's correct. As I read that stipulation, the only misconduct that they found was the fact that the money was taken from one bank, placed in another bank, and then used to pay the taxes of the respondent. There was no mention made of the rounding off to the higher hour, the unreasonable fees.
Do you know whether that information had been presented in Missouri, or do you think it was just not part of the case in Missouri?
I
don't
know that. Just from reading the documents, I didn't see any mention made of that.
Okay. What I'm trying to get at, of course, is whether they rejected that for some reason or just didn't know about it.
I don't think so. I think it was just a stipulation entered into between counsel and disciplinary counsel in Missouri.
Okay. Thank you.
There was also no mention made of the situation with the respondent's wife.
Right.
Any further questions of counsel? Any further presentation?
No, Your Honor.
Thank you, counsel.
Thank you.
Mr. Chief Justice, Your Honors, may it please the Court, I'm John Ambrosio. I represent the respondent who's present here today. We've got 3 cases with sad facts. This is maybe one of the saddest of all of them. We've got a man who was at the pinnacle of our profession for years and years and years with a good law firm. And what happened, no one will ever be able to tell. He indicates to me, and he indicated to the panel, that when he first took money out of the trust, he had money to pay his personal taxes. But because of problems that he was having with his wife, he was afraid to go to her and say, we owe X number of dollars in taxes, so he took money from the trust. He's been stand-up from the beginning. He's been stand-up and admitted every transgression that he has committed. He didn't put the disciplinary administrator's office to the harsh test of days upon days upon days of presenting records and going through banking channels, etc. He stood up, he entered into a stipulation. He's 69 years of age, he'll be 70 years of age. The reason my colleague asked for indefinite suspension and the reason I joined in that recommendation, and is this a disbarment case? Absolutely, if you follow the law that has been set down by the Supreme Court for years and years and years. When you touch the trust account, you're gone. I think what my colleague and I don't mean to speak for my colleague is, and thank God that he has a little bit of a feeling deep down in his heart for people, you work this long as this man has to get to the pinnacle of the career. Someday he'd like to have the license back, not to practice law. He will never practice law again. He's told me that. He's told Stan that. He's told Mr. Hazlitt that. He'll tell you that. But he'd like to go to his grave with that law license. It's that important to him. Now, that may not sound like much, but he stood up, he accepted his punishment, he accepted it over in Missouri. They entered into a stipulation. He admitted every sin that he committed.
Mr. Ambrosio, is the final hearing report inaccurate? Because I'm reading here a quote about the accepting responsibility where your client says, "It is possible I could have been more precise in describing, and perhaps I could have been more efficient," goes on to say, the last sentence there is, "I did not take advantage of the trust estate or its beneficiaries and did not act dishonestly or deceitfully." Now that's the quote that the hearing panel is ascribing to your client, and I don't see that as accepting responsibility under the facts of this case.
Most respectfully, I disagree. I hear what the panel said. I don't take any issue with the panel said. But I think the fact that he stood up and said, "I did this," didn't make the disciplinary administrator's office put on their entire case, which would have taken days. And maybe I am making it synonymous within federal court, where you admit your indiscretions, regardless of what you say, you get the 2 or 3 points off. I think it's the same in this case. He's admitted responsibility both in Missouri and here, and he is remorseful. And there I disagree with the panel, although I didn't take exceptions, which would have been ludicrous to take exceptions to this case. They thought he wasn't remorseful. I think he's remorseful. I think Stan thinks he's remorseful. If Stan hadn't thought he was remorseful, he would not have made the recommendation that he had made. My client would like to address the court.
Thank you, John. Ladies and gentlemen, I'm John Davis. I've not had the opportunity to appear before the court before, and I'm sorry it's in this set of circumstances. I want to apologize to all the people that have been affected by my actions. These include, of course, the client, and as well as her beneficiaries. I've had other clients who've had to terminate their relationship with me, and I've had to terminate my relationship with them because of this activity. My family, I apologize to them for all the stress this has put them through, my friends, and of course those involved in the disciplinary proceedings. My actions have had a major effect on a large number of people. I've learned a great deal about myself as a result of this proceeding. In the course of reviewing my actions through this, I've been in counseling for a couple of years now. I've been in joint counseling with my wife for a year and a half now. I participated in the Missouri Lawyers Assistance Program. Looking back, I can see what kinds of things may have led to my bad decisions in this. And the counseling has been particularly helpful to me. I appreciate the support my clients have given me. In February 2010, when I left Stinson, I was asked to resign, of course, and I opened my own office. I wrote a number of clients and said, "I'd like to continue to represent you." Over 90% of the people I contacted said, "I'd love to continue to work with you." In the course of these proceedings, I've, of course, realized I'm apt to be suspended, and I've gradually wound down my practice. And I've taken on a few cases that were short and I could finish quickly. At this point, I'm not practicing law. I recently had a referral from what might have been a particularly good client. Actually, it was a resident of Topeka. in the initial call to me, he kind of joked with me and said, well, there's somebody on the internet who's got a name like yours who's going through disciplinary proceedings. I hope it's not you. Unfortunately, I had to say it is me. I borrowed my client's funds at a time when I was under pressure from a number of different things, family things, practice things. It wasn't a good decision. Anyway, I apologize for that and the injury that caused anybody, particularly in the clients. I was admitted to practice in Missouri in 1968, as Stan said, and in Kansas in 1993. My reputation generally has been very good through that period of time, and I've had the opportunity to have some wonderful clients, to be active in various bar association activities, be involved in some really productive civic activities, and to have a terrific and supportive family. I enjoy the law. I enjoy the opportunity for assisting people to understand what the law provides and how they can arrange their situation to comply with the law and fit within the opportunities the law allows. I also appreciate what the law does for an orderly legal system in the United States, and I'm proud to have been able to practice law for 40 years, be a part of that. And I would like to have my license back at some point in time. My sense is that I'm a good person and I made some mistakes, and I certainly will not make the same ones again. Thank you for your consideration.
Mr. Davis, is the final hearing report accurate in terms of restitution, what it says about restitution paid by you personally versus paid by the firm or others?
The firm made restitution for the fees and made restitution for the issues over the billing.
And your contribution to
and
that
I-
was the amount that you had left behind in your...
and equity in the firm, and then I refunded the money I wrote the checks for. The fees were paid to the firm throughout, not to me directly.
I'm interested, counsel, in your characterization as being regretful for the money that you borrowed.
Say it again. I
I'm
didn't hear you real
interested in
clearly.
your characterization that you're remorseful or you regret borrowing money. Is that still your belief as to what happened?
Yeah, yes. At that point in time, I was, as I say, under a whole bunch of stress. One of the ones was my wife was on my case about how we were handling our finances, and I didn't want her to see that I was about to borrow on our line of credit to pay that tax. I did borrow on our line of credit to repay the tax, repay the money.
I think
I misunderstood what you were telling me. I thought that you were saying you borrowed money from the client. Did I misunderstand you?
No, I don't think you did. I think that's correct.
So it's your belief that you borrowed money from the client, and then when you made restitution, the client was made whole?
Yes.
Thank you. We have any further questions of counsel? Yes.
I do. I just clarify, in 2008, when you paid your wife $55,095 out of the trust to be Ms. Neville's advocate, at that time she was in a nursing facility, was she not, Mrs. Neville?
Yes, she was.
And so she had 24-hour care at the nursing facility?
She had whatever sort of level of care you get in a nursing facility, which, is not particularly responsive to folks. I hope whenever we're in retirement centers, if we are.
Thank
But
you.
the answer is
Good
yes,
care.
Your Honor.
Yeah, thank you.
Is that right? Okay.
Any further questions of counsel? Any further presentation?
No, thank
No,
you.
Your Honor.
Thank you.
Thank you, John.
Court will take this matter under advisement. We now turn